city in America where age is just a number. Of course, we are talking about Washington, D.C. as we continue to look at the issue of ageism across our country. So much attention is paid to the age of the two men running for president. But what about the House, the Senate, the Supreme Court? House Speaker Emeritus Nancy Pelosi, 84. On the Senate side, Mitch McConnell, 82, as is Senator Bernie Sanders. Consider the scientific community. Dr. Anthony Fauci says he's 83, and he ain't going anywhere anytime soon. So why is ageism and ism everywhere, it seems, but Washington, D.C.? Is this a case where Capitol Hill says, do as I do and not as I say? Let's go right now to our guest, John Bell. And Mr. Bell, thanks for being with us this afternoon. Is this a case where Capitol Hill says, do as I say and not as I do?
Well, I'll tell you that everyone should really follow DC's lead. I mean, we don't want mandatory age retirements. That's not the right way to go. However, I do agree that if you're giving people mental cognitive tests, regardless of their age, maybe everybody in that job or that opportunity, and if they fail, they can't pass those exams, then there's a question of whether or not they have the mental competence to perform those jobs, or in some situations, the physical competence, if in fact it involves some type of physical labor, like there is mandatory requirements for police officers and firefighters. But putting that aside, if you're treating everybody equally and everyone has to pass these tests, then in that situation, a situation where they're forced out would not be discrimination and would be fine.
Hey, John, guess who the ultimate jury would be, though, in Washington, D.C.? Because should one of these cases reach the Supreme Court, let's look at the age there. Clarence Thomas is 75. Samuel Alito is 74.
Well, it's funny that the Supreme Court hasn't been very friendly to the elderly class in age discrimination cases. In the Supreme Court in 2009, there was a decision that if you're approving discrimination in employment, you can't show a mixed motive like you can for other causes of actions like race, religion, gender, and other protections under Title VII. The ADEA, which is the Age Discrimination in Employment Act, covers people who are over 40 and has a but-for test. You can't show mixed motive. You have to show that the termination or the non-hiring or non-promotion was specifically related to your age, and that was the motivating factor.
John, you know the old saying, money talks and something else walks. When it comes to age discrimination lawsuits, should someone sue their company for age discrimination, are the settlements commensurate with what the argument is that this may be the end of my career?
That's a great question, and it depends on the facts. Depends on the evidence that you have. If you have direct evidence of discrimination, like someone comes up to you and says, hey, you know, you're reaching that age, why don't you consider retirement and getting pushed out? That's direct evidence, especially if you have that in writing. However, if you have to prove something through circumstantial evidence, in other words, the older workers are being fired and replaced by younger workers, you have to look at the facts of the case. Are the younger workers being paid less? Maybe it was just saving money. Or is it really legitimately discrimination? But then you have to turn to federal laws versus state laws. For example, in New York, where I practice, if an employer has more than 4 or more employees, you could sue for age discrimination in court. If you're suing under federal law, it has to be 20 employees or more. So you have to look at your local statutes as well to see even if you can bring such a claim.
So, John, if we're talking about Washington, D.C., you hear an awful lot of people say term limits. Is the argument for term limits ageism?
I believe it is. Generally speaking, it can be ageism in a sense. I mean, obviously, right, for presidents, we have 2 terms, 8 years. I don't know if that's long enough to be considered age discrimination. I actually don't think that it is. But in a situation involving certain term limits over a certain length of time, at that situation, I think they are possibly targeted at someone's age, yes.
So, John, the bottom line then with Washington, D.C. is what? We let people just stay in Congress and in the Senate and on the Supreme Court until they just get so old that, in the case of the court, they die.
So, again, kind of going what I said earlier, I think an age limit is the wrong way to go because I know plenty of 80, 81, 82-year-olds that are very with it as opposed to some 40, 50, and 60-year-olds that are not. So I'm all for a cognitive ability test to make sure that a person is mentally capable of performing the job that's required for everybody to take alike, not based on race, age, religion, gender, disability, which are the protected classes under the law. So if you're giving everybody a mental capacity test equally, I think that would be the right way to go.
Attorney John Bell, just in case you're curious, we're recording this segment. Just in case you have to argue a case before the Supreme Court, you can say, hey, I'm on your side. John Bell for us in New York. John, thanks for being with us.
I appreciate you having me on. Thank you.
You got it. Let's go back out.